It is kind of funny when you really sit down and think about the rules that govern our lives.
Oh, for sure, because we just assume they're public, right?
Exactly. There's this huge underlying expectation of public visibility. It's the social contract we all just instinctively operate under every single day.
Yeah, you don't even question it.
Right. Like you drive down the highway and you see this massive white sign with stark black numbers, and the state is essentially just pointing at it saying, there it is. That's the rule. 65 miles per hour.
It is visible, it's standardized, and it applies to everyone.
Exactly. It applies to the teenager in the rusted-out sedan just as equally as it applies to the CEO driving, I don't know, a luxury sports car.
Which creates this really powerful sense of shared reality for us.
Yeah, it really does.
I mean, we find immense comfort in knowing that the boundaries are drawn in permanent marker, and they're right there for everyone to see.
Right. And if you violate that boundary, well, the consequences are a matter of public record.
And this is where it gets wild, the moment you step off that public highway and walk into the business world.
Oh, man, yeah. The moment you sit down at a negotiation table,
That visible speed limit sign just completely vanishes.
it's just gone.
Yeah.
You are suddenly looking at this landscape that is governed entirely by invisible rules, by private laws.
And honestly, for the vast majority of people, that landscape is just completely murky.
Oh, 100%. I mean, think about how often you sign a piece of paper. Maybe you skim the bold headings if you're feeling ambitious. But the actual mechanics of what you just agreed to, they just remain completely hidden in plain sight.
That is the absolute definition of a hidden matrix.
Yeah.
Every single time two parties sign a commercial agreement, they are literally severing themselves from the default public rules of engagement.
Wow. Severing themselves. I like that.
Yeah. They are creating this bespoke, totally private universe of laws that apply solely to them. They are dictating the physics of their own relationship.
And if you don't speak the highly specific, engineered language of that universe, well, you are flying completely blind.
You really are. You're just hoping for the best.
Which is exactly why we are doing this today. This brings us to our mission for this deep dive. We are calling this Masterclass 1, Thinking Like a Contract Drafter.
Because if you can understand how those invisible rules are actually built, you basically unlock this kind of X-ray vision for the business world.
Right. You start to see where the leverage actually lives in a deal, rather than where people just pretend it lives.
And to decode all of this, we are drawing exclusively from a truly foundational text in the legal world.
Yeah, this is the gold standard. It's called Drafting Contracts, How and Why Lawyers Do What They Do. And this is the second edition by Tina L. Stark.
And it is widely considered the absolute gold standard for teaching deal lawyers how to do their jobs.
How to translate messy, highly emotional human negotiations into, precise, mathematically rigid legal agreements.
Stark's work is just phenomenal because she completely bypasses all those theoretical, philosophical debates you might find in a typical first-year law school torts class.
Oh, thank goodness for that. Nobody wants to debate the philosophy of a contract right now.
Right. She focuses entirely on the architecture of risk. Because a contract, as Stark lays it out, is not just some dusty repository for complicated words like heretofore and whereas.
So there are plenty of those words.
There are, but it is a living, breathing mechanism. It's designed to aggressively protect a client's interests while simultaneously navigating the really fragile psychology of the opposing party.
Okay, so before we can even begin to pull apart the specific clauses, the actual nuts and bolts of a contract, we have to talk about the fundamental psychology of the person actually typing the words.
This is such a crucial starting point.
We really have to look at the massive difference between mere, writing and actual drafting. Because I'll be honest, I always held this incredibly naive assumption that a lawyer was just a lawyer.
A lot of people think that.
Right, like you get a law degree, you know the law, you apply the law. But Stark highlights this profound cognitive divide between litigators and deal lawyers.
Yes, so litigators are the lawyers who go to court and fight it out. Deal lawyers are the ones at the negotiation table actually drafting the agreements.
And their brains are basically pointed in completely opposite directions on the timeline of reality.
The temporal focus is entirely inverted. It's fascinating. Litigators look backward, always backward.
Right. They are dealing with a static, unchanging set of past facts.
Exactly. A breach already happened, a car crashed, a partnership dissolved in a bunch of acrimony. The event is over.
So the litigator's job is to take those unchangeable facts, apply existing case law to them,
Huh.
and basically win a zero-sum war against an adversary.
In front of a judge or a jury, they are essentially dissecting a corpse to determine the cause of death.
Which makes the litigator basically a forensic detective.
That's a great way to put it.
They're looking at the blood spatter and the shattered glass, trying to reconstruct the past to get a conviction or a settlement.
But the contract drafter, the deal lawyer, they're looking forward.
They aren't fighting over a past crash.
No, they're trying to establish the parameters of a future relationship. So if the litigator is the forensic detective.
Then the contract drafter is like an architect.
Yes, exactly. They are looking at an empty plot of land and designing a skyscraper that has to withstand future, entirely unpredictable earthquakes.
Wow, designing a building for earthquakes that haven't even happened yet.
That analogy perfectly captures the heavy burden on the drafter. And designing that earthquake-proof skyscraper requires a very specific, highly cultivated ability. Stark calls this the translation skill.
The translation skill. Okay, break that down for me.
Well, the core competency of a drafter is not just reciting case law from memory. It is taking the raw, messy material of the business deal and translating it.
The raw material being like what?
The client's aggressive financial goals, their absolute worst nightmare scenarios, the really fragile compromises they just hashed out over a tense 3-hour phone call.
Oh, right. All that chaotic human intent.
Exactly. They take all of that and translate it into standardized, bulletproof contract concepts.
I want to linger on that translation process for a second because the style they use to do this is heavily debated. The text refers to this style as contemporary commercial drafting.
And the source makes a very, very sharp distinction here.
Yeah, this is not the plain English movement.
Not at all.
The plain English thing has completely taken over consumer contracts. Like when you sign up for a new credit card or, download a software update on your phone.
Right. The terms are stripped down to the bare essentials so a normal, everyday consumer can comprehend them. It says things like, you agree to pay us the balance. It's designed to be approachable.
But commercial contracts actively resist that level of simplicity.
They have to. Plain English is wonderful for consumer protection, but business contracts serve a completely different master.
The source quotes Carl Felsenfeld here, right?
Yes, he's a pioneer in the legal drafting field. And he makes this really compelling case that a business contract must retain its heft.
Its heft. I love that word for it. It just sounds heavy.
Because it is. In commercial drafting, if a risk can be perceived no matter how remote, you must draft a defense against it.
You do not leave things to chance. And you definitely don't rely on the so-called good faith of the other party.
Oh, never. Relying on good faith in a multi-million-dollar supply chain agreement is essentially professional malpractice.
You wouldn't draft a 10-year semiconductor manufacturing agreement between two massive corporations using informal pronouns like we and you.
And you certainly wouldn't just say, hey, we promised to do our best.
Right. It has to be formal. It has to be heavy. The financial implications demand that level of density.
And that density is a feature, not a bug. Drafting a commercial contract is a highly sophisticated act of multidimensional problem solving.
Because a well-constructed contract has to bridge this massive chasm of differences.
It does. It has to give the opposing side just enough of what they need so they feel comfortable actually signing the document,
while simultaneously, and usually quietly, reallocating all the catastrophic risks back onto their shoulders.
That is the delicate dance of drafting.
Okay, that brings up a really fascinating dynamic. If the litigator is trying to destroy the other side in court, and the drafter is acting as this architect building a shared structure, it almost sounds like deal lawyers are just inherently more collaborative.
They definitely cultivate that image.
Right. Like, are they just sitting around a mahogany table singing Kumbaya, trying to make everyone happy? It seems like they don't care about winning in the traditional sense.
That is a very common misconception, but it couldn't be further from the truth. Deal lawyers absolutely want to win.
Okay, so their competitive drive is just as fierce as the litigators.
Oh, absolutely. But the definition of winning in their arena is vastly different.
How so?
Winning for a deal lawyer means getting the deal closed, getting the building fully constructed and operational,
while quietly ensuring that if a massive structural failure does occur 5 years from now, it is the other party's side of the building that collapses.
Exactly. It is a philosophy of competitive cooperation. Both parties have a massive financial incentive to get the deal done, but they are constantly, ruthlessly maneuvering to protect their own downside.
Competitive cooperation. I love that framing. So if These drafters are the architects of this shared earthquake-proof structure. They can't just draw a pretty picture on a whiteboard and call it a day.
No, they need actual physical materials to build the thing.
They need bricks, mortar, steel beams, and wiring. And our source text identifies exactly 7 building blocks.
7 specific contract concepts.
And these form the molecular structure of literally every single contract ever written, right?
Every single one. Whether it's a 2-page NDA or a 1,000-page merger agreement, it is built from these 7 blocks.
So once you internalize this framework, the entire legal world kind of demystifies itself.
Completely. You can take any complex agreement, lay it flat on a table, and just deconstruct it piece by piece.
Okay, let's examine the foundational layer first.
Yeah.
The first 4 building blocks deal primarily with establishing current facts and securing future promises. Right. Let's lay the very first brick. Building block number 1, representations.
So a representation is a very specific legal tool. It is a statement of past or present fact.
Crucially, it is made at a highly specific moment in time.
Usually the exact moment of signing or closing the deal, and its sole purpose is to induce or convince the other party to enter into the contract.
The source gives a really straightforward real estate example here.
Right. The house is wired for internet.
Okay, so if I am buying a commercial property from you to set up a tech startup, I need to know that factual reality right now before I wire the massive down payment.
Exactly. You are relying on that statement of fact to make your financial decision.
But words on a page are entirely meaningless unless they carry enforceable consequences, which introduces building block number 2, warranties.
Right. A warranty is a contractual promise that if the statement made in the representation turns out to be false.
The party who made the statement will indemnify the other party.
Yes. Meaning they will financially compensate them for any and all damages suffered because the statement was untrue.
Now, I think this is where the average business person or even like a junior lawyer just starting out starts to pull their hair out.
Because it feels redundant.
Because on the surface, it feels incredibly redundant. Let's stick with the commercial property example. If you represent to me that the roof of the warehouse is brand new and I buy the building, and the first time it rains, the roof just collapses because it's actually 30 years old.
Oh, I lied to you.
You lied to me. I already have a reason to be furious. Why on earth do I need a separate, distinct warranty clause promising that you'll pay for the damage?
Ah, okay.
I mean, we all know that proving common law fraud in the court system is an absolute nightmare. You have to establish malicious intent, reasonable reliance.
Yeah.
It's a mess. So is putting a warranty next to a representation basically just a contractual bypass to avoid the tort system entirely?
That is a brilliant way to conceptualize it. You hit the nail on the head regarding the burden of proof.
Okay, explain that.
If we only had a representation in the contract and the roof collapsed, you would have to sue me for common law fraud or misrepresentation.
Which takes years.
And to win that case, you have to prove that I knew the roof was old, that I actively intended to deceive you, and that a reasonable person in your position would have relied on my lie without hiring their own independent roof inspector.
It is a grueling, incredibly expensive forensic battle.
A battle that litigators might love, but deal lawyers want to avoid at all absolute costs.
Precisely. So by pairing the representation with a warranty, the drafter completely changes the legal battlefield.
Yes. The representation establishes the factual baseline you relied upon, and the warranty contractually guarantees your monetary remedy, the indemnity payout, without you ever having to prove my state of mind.
Or my intent to commit fraud.
Yeah.
It downgrades a messy, subjective tort claim into just a clean, objective breach of contract claim.
Exactly. The roof leaked, the warranty was breached. Write the check.
So it's like buying a used server rack for a huge data center. The representation is the vendor saying, these servers operate at 100% capacity.
And the warranty is the legally binding addendum that says, and if they overheat and melt down tomorrow, I am contractually obligated to pay for the replacement hardware and all the lost revenue.
I don't have to prove the vendor intentionally scams me. I just have to show the judge the melted servers.
That captures the mechanics perfectly. And, when you understand that, you immediately see the strategic trench warfare that happens during the drafting process.
Oh, the fighting over the words.
Exactly. If you are the lawyer representing the seller, the party making these representations and warranties, your entire job is to heavily qualify those statements.
You want to shrink the target on your client's back.
You push to add phrases like, to the best of the seller's actual knowledge, the servers operate at capacity.
You want to limit the liability to only things your client explicitly provably knew about.
Right. But if I'm representing the buyer, the party receiving those representations, I am fighting tooth and nail to keep them broad, absolute, and entirely unqualified.
I want the contract to simply state, the servers operate at a 100% capacity,
Right.
period. Full stop. No wiggle room.
Because the broader and more absolute the statement is, the easier it is for me to trigger that warranty and claim a misrepresentation later if anything goes wrong, regardless of what the seller actually knew.
It is a quiet, highly technical war fought entirely over the qualification of sentences. It's absolutely fascinating.
It really is. Now, that covers the factual foundation, the past and the present. But a business deal isn't just about what is true today, it's about what we're going to do tomorrow.
Right. That requires action. Which brings us to building block number 3, covenants.
A covenant is simply a promise to do or not to do a specific action in the future.
It creates an absolute strict duty to perform.
Yes, like the buyer shall wire $50 million to the seller's account on Friday at noon. It is an affirmative duty.
And building block number 4 is inextricably linked to it. It is the flip side of the coin, rights.
Exactly. If one party has a covenant creating a strict duty to perform an action, the other party simultaneously possesses a right to receive that performance.
So if my client has a covenant to wire the $50 million, your client holds the corresponding right to receive the $50 million.
They are Siamese twins. You literally can't have one without the other.
They are the fundamental economic engine of the contract. Those 4 blocks, representations, warranties, covenants, and rights, they form the substantive core of what people imagine when they think of a business deal.
They define who stated what facts, who promised what future actions, and who is entitled to what benefits.
Okay, so that gives us the bricks and the mortar, the facts and the absolute promises. But anyone who has ever done business knows that human relationships, especially commercial ones, are rarely built on unconditional absolute promises.
Very rarely.
We don't just say, I will definitely buy your company on Friday. We say, I will buy your company on Friday, assuming your third quarter revenue hits the projections.
Right. Sometimes obligations only activate if a specific domino falls first.
And that brings us to the final 3 building blocks, which act as the complex triggers and the internal rulebook of the contract's universe.
This is where the drafting elevates from simple construction to complex architecture. Building block number 5, conditions.
A condition is a specific state of facts that must exist, or an event that must occur, before a party is legally obligated to perform a covenant.
Yes, I will purchase the commercial real estate condition if, and only if, the city approves my zoning variance for a mixed-use development.
That is a classic example, and the source text makes a really vital distinction here between 2 primary categories of conditions, walkaway conditions and ongoing conditions.
So a walkaway condition is typically tied to the ultimate closing of a major transaction. If the condition fails to materialize, say, the city denies your zoning variance, the corresponding obligation to buy the property never activates.
And more importantly, you can walk away from the entire contractual relationship without being in breach. You are legally absolved.
You just pack up your briefcase, shake hands, and say, well, the condition wasn't met, the deal is dead, no harm done.
But an ongoing condition operates differently, right?
It does. It regulates the flow of obligations during the active life of a long-term contract.
Okay, give me an example.
For example, in a multi-year construction contract, you might see a clause like, the developer will pay the monthly invoice condition, provided the independent architect has certified the structural integrity of that month's work.
Okay, so if the architect refuses to certify the work in July, the developer's covenant to pay the July invoice is suspended.
Right. The condition wasn't met. But the entire contract isn't terminated. The contractor just has to fix the structural issues and get the certification in August.
The relationship survives the failed condition.
Exactly.
Okay, that makes perfect logical sense. But I need to pause here because the text specifically calls out a massive linguistic trap that drafters fall into when trying to write conditions.
Oh, this is a big one.
I want to see if we can unpack the logic behind it, because on the surface, it feels like semantics. But Stark treats it as a fatal error.
It is fatal in court. Let's hear the example.
Let's use a very basic formulation. If I write in a contract, if X happens, Y is obligated to perform. That is clean. That is an undeniable condition.
Correct.
But what if a drafter writes, if X does not happen, Y is not obligated to perform?
Oh, boy.
To a layperson or even a junior lawyer rushing through a red line document at 2 a.m., that conveys the exact same fundamental intent. But Stark explicitly labels that second formulation as wrong. Not just messy, but fundamentally incorrect. Why?
This is one of the most conceptually challenging hurdles for new drafters. It
Mm.
gets to the absolute core of how a deal lawyer's brain has to function.
Okay, walk me through it.
When you write, if X does not happen, Y is not obligated, you haven't actually drafted a condition. All you have done is accurately describe the common law consequence of a failed condition.
Okay, let's slow down and translate that. What is the practical danger of describing the consequence instead of creating the condition?
Let's use an analogy of a complex electrical circuit board.
Okay, I'm with you.
A properly drafted condition is the physical switch that allows the power to flow. If X happens, the switch closes, and Y must perform. The power turns on.
Right.
If instead you write, if X does not happen, Y does not perform, you are merely looking at a dark room and describing the state of a dead circuit.
You haven't actually built the switch that turns the power on in the first place.
Exactly. If this goes to litigation, a judge might look at that clause and say, I agree that Y doesn't have to perform if X fails. The contract says that clearly. But counsel, point to the clause that says Y ever has an affirmative duty to perform if X does happen.
Oh, wow. By focusing on the negative consequence, the drafter forgot to affirmatively create the obligation and the trigger.
They described a dark room without installing a light switch.
That is an incredibly subtle distinction. But mathematically, legally, it is massive. You have to build a switch. You can't just mandate what a dark room looks like.
That is the essence of architectural drafting. Every clause must have structural integrity.
Okay, moving to building block number 6, discretionary authority.
This one is relatively straightforward, but incredibly powerful. It grants a party a choice or permission to act.
It establishes the right, but crucially not the obligation, to do something.
Right. Like, the acquiring company may terminate this merger agreement if the target company's stock drops by more than 20%.
The acquirer doesn't have to terminate. They might still want the company at a discount, but they possess the discretionary authority to pull the ripcord if they choose.
It dictates who holds the strategic cards when circumstances change.
Precisely. And finally, we arrive at building block number 7, declarations.
A declaration is a statement of fact that both parties mutually agree upon to govern the mechanics of the contract itself.
It usually establishes a definition or a standard operating policy for the agreement. The way I always visualize declarations is by thinking about the rules of a board game.
I love this analogy.
Right, like when you open a brand new game of Monopoly, the inside of the box lid has a rule book that declares passing go entitles a player to collect $200.
You don't sue the game if it calls a little metal piece a thimble, or if it defines a specific square as free parking.
Exactly. It's just the mutually agreed upon baseline reality for the universe of that specific game.
That is the perfect way to understand it. For the purposes of this merger agreement, business day shall mean Monday through Friday, excluding federal holidays.
That is a classic declaration.
It defines the physics of the contractual universe. However,
There's always a however.
because the lines between these building blocks can occasionally blur in complex documents, Stark provides a magnificent analytical tool called the monetary remedy test.
Right. This is to figure out if a clause is truly a benign declaration or if it's something much more dangerous wearing a disguise.
Exactly.
I love this test. Let's apply it to a hypothetical. Walk us through how the monetary remedy test actually works in practice.
The test is designed to strip away the grammatical disguise of a sentence and reveal its true legal nature. If you are reviewing a clause and you aren't certain which building block it represents, you ask yourself one simple question. If this statement turns out to be entirely false, would the aggrieved party want money damages as a remedy?
If the answer is no, they just want the error corrected or the contract canceled, then it is truly just a declaration.
Right. Let's test that. Let's say the contract declares the designated closing date for this transaction is Friday, October 14th.
But it turns out October 14th is actually a Thursday this year.
Exactly. If that statement is false, do you want to sue the other party for millions of dollars in damages?
No. I mean, I just want to cross out Friday, write in Thursday, and close the deal. It's just a clerical reality check. So that is a true declaration.
Exactly. The failure of the statement doesn't create a financial harm that requires indemnification. But let's run the test on a different clause.
Hit me.
What if the contract says, in what looks like a simple declarative sentence, the target company's proprietary software contains no open source code? If that statement turns out to be false, if the software is actually full of stolen open source code, do you want money to fix it?
Absolutely, I do. My client just paid a massive premium for proprietary IP that is now essentially worthless. I want millions of dollars in damages to rewrite the code base and settle the inevitable copyright lawsuits.
Therefore, the statement, "The target company's proprietary software contains no open source code," completely fails the monetary remedy test.
It might be written grammatically like a simple declaration, but it's actually a representation and a warranty hiding in plain sight.
The danger here is profound.
Because if a junior drafter doesn't know the difference,
They might bury that critical sentence in the definitions section of the contract instead of the representations and warranties section,
and if it's in the wrong section, it might not be covered by the indemnification clauses.
which severely compromises the client's ability to actually get paid when the software turns out to be compromised.
Wow, that highlights the stakes perfectly. So taking a step back, we now have the complete architectural framework. We have the 7 building blocks.
We have the bricks, the conditional switches, the discretionary authorities, and the declarative rulebook.
The fundamental question now is application. How do we actually build the wall?
Right.
How do we take a client's messy, urgent business demand, like a client screaming into the phone, just make sure they update the security protocols on the servers ASAP? How do we translate that human urgency into an airtight, enforceable legal clause?
This transitions us directly into the core of the drafting process, the translation skill in action.
Okay, walk me through it.
To execute this translation, the drafter cannot just transcribe the client's emotional demand. They have to run that vague instruction through a rigorous analytical filter. Stark refers to this as the who, what, when, where, why, how, and how much test.
It sounds incredibly similar to the basic journalistic filter you learn in, like, high school English.
The framework is similar, yeah, but the application is entirely focused on eliminating risk and ambiguity. Let's run your client's panic demand through the filter. Make sure they update the security protocols on the servers ASAP.
Okay, let's filter it. Who is obligated to act?
The vendor.
What is the specific obligation?
To install the version 4.2 security patch
Where?
on the primary East Coast server cluster
When?
within 48 hours of contract execution,
How?
with zero downtime during standard business hours.
I see. If the drafter fails to define the how and the when with absolute mathematical precision, update the protocols becomes a massive vulnerability.
Because ASAP to the vendor might mean next week when they have free time. To your client, it meant tomorrow morning.
And that ambiguity is the breeding ground for multi-million-dollar litigation.
That level of granularity is absolutely essential.
And the text provides a really specific example of fixing bad drafting that I found incredibly revealing about how courts actually interpret language.
Oh, the shall debate.
Yes. Stark shows how a less experienced lawyer might draft a payment clause like this. The producer is responsible for paying the screenwriter $100,000.
And she aggressively calls that out as terrible drafting.
She insists it must be changed too. The producer shall pay the screenwriter $100,000. Now, I want to push back on this.
Go for it.
Because to a business executive reading that contract, this sounds so incredibly pedantic. It sounds like lawyers just justifying their billable hours by arguing over synonyms.
I hear this complaint all the time.
Right, like does changing is responsible for to shall actually matter in front of a judge in the real world? Isn't the commercial intent blindingly obvious? A judge knows what responsible for paying means.
It absolutely sounds pedantic right up until the moment you are the litigator standing in court desperately trying to collect your client's $100,000.
Fair point.
To a judge interpreting a commercial agreement, words do not have flexible conversational meanings. They have exact architectural weight. Let's return to your earlier analogy about writing computer code.
Right, the rigid logic of programming.
If you are an engineer writing software, and the specific programming language requires a hard bracket to execute a critical command, and you decide to use a parenthesis instead.
Because you think it looks nicer. Or because the intent is obvious.
Exactly. What happens when you run the code?
The code breaks. The program crashes. The machine processing the code doesn't care about your intent. It only recognizes the authorized syntax.
That is exactly how courts view commercial contracts. In contemporary commercial drafting, the word shall is the hard bracket.
It is the universally recognized, legally authorized code that creates a covenant, an absolute, unconditional duty to perform an action.
Yes. If you use a conversational euphemism, if you write, is responsible for paying, or will undertake to pay, or agrees to consider paying, you didn't use the hard bracket. You used a parenthesis.
And when the producer inevitably refuses to pay and you drag them to court, the producer's highly paid litigator will stand up and argue.
What? They'll say, Your Honor, look at the text. My client was merely responsible for the overarching concept of payment, perhaps managing the accounting department, but they did not have an absolute affirmative duty to execute the wire transfer themselves on that specific date.
If they meant to create a strict duty, they would have used the word shall.
Boom. And suddenly, your enforcement mechanism crashes. The ambiguity creates a loophole, and the client's money is tied up in years of litigation, all because the drafter used passive, weak language.
You must always use shall to create an obligation. It's non-negotiable.
That leads to a series of strict syntactical rules for this legal code. Keep the core of the sentence tight. Subject, verb, object. The producer subject, shall pay. Verb, the screenwriter object.
You put short, critical phrases before long, qualifying phrases.
And crucially, you must aggressively use the active voice rather than the passive voice.
Oh, this is a big one.
You never write, payment shall be made by the producer. You write, the producer shall pay.
Because the active voice forces the drafter to explicitly identify the who. The passive voice allows the responsible party to hide in the shadows of the sentence.
Yes, the passive voice is a hiding place for liability.
If a commercial lease says, the structural integrity of the roof shall be maintained, and the roof caves in destroying millions of dollars in inventory, who do you sue?
Exactly. The sentence commands that an action happen, but it doesn't assign the duty to anyone. It could be the landlord, it could be the tenant.
But if the active voice is used, the landlord shall maintain the structural integrity of the roof, the liability is crystal clear.
And this discussion of weak drafting leads us directly into one of the most fatal flaws a drafter can make. What Stark calls covenants posing as declarations.
This one blew my mind because it is so easy to miss if you aren't trained to look for it. Walk us through how a covenant disguises itself.
Okay, imagine a drafter is working on a complex mezzanine loan agreement, and they write a clause that says the term of the loan is 5 years.
Okay, that sounds normal.
Grammatically, if you look at that sentence, it is constructed as a declaration. It is stating a fact about the universe of the contract. The loan is 5 years long.
Right.
But if you run that through the translation filter, what did the bank actually mean?
They meant the borrower shall repay the principal and interest of the loan in exactly 5 years.
Yes. By drafting the business intent as a simple declaration of fact, they completely stripped out the shall. They removed the active enforceable obligation from the sentence.
Oh, wow.
That is the danger. If the borrower defaults and refuses to pay in year 5, the bank tries to sue for breach of covenant. But the borrower's lawyer points out that the contract merely declares the abstract concept that the term is 5 years.
It doesn't actually contain a covenant commanding the borrower to write a check.
The drafter has essentially neutered their own client's ability to enforce the central action of the agreement. They built a car without an engine.
Okay, so if the drafting process requires this level of microscopic precision, if it really is akin to writing complex software, where a single misplaced euphemism or disguised declaration can crash a $100 million deal.
It's terrifying.
It makes total sense that junior lawyers are absolutely terrified to open a blank Microsoft Word document and write a contract from scratch.
No one writes from scratch. It's too dangerous.
Which transitions us into the reality of how these documents are actually created and the massive pitfalls involved.
Yeah.
Because junior lawyers are understandably terrified of making a fatal structural error, they rely heavily on old templates.
They go into the law firm's archives and pull up documents that have been used by senior partners for 2 decades. These are known as precedents.
Precedents are the absolute lifeblood of modern corporate law firms, right?
They ensure consistency and efficiency. You can't spend 3 weeks reinventing the wheel every time a client wants to acquire a mid-sized software company.
But while that efficiency is vital, relying blindly on those historical precedents leads directly to the most catastrophic drafting mistakes Stark identifies.
The first and most pervasive of these is the mindless markup.
The mindless markup. This is the act of taking an old form and just blindly copying the historical clauses without stopping to critically analyze if they actually apply to the bespoke reality of the new business deal.
It is the trap of intellectual laziness.
Give me an example of how this goes wrong.
Imagine you grab a beautifully drafted, battle-tested precedent that your firm used for the acquisition of a massive physical shopping mall.
Okay, a big physical asset.
It has airtight clauses regarding environmental liabilities, escalator maintenance, and tenant foot traffic guarantees.
Makes sense for them all.
But you take that template and use it as the base for your new deal, which happens to be the acquisition of a purely digital SaaS company that doesn't own a single piece of physical real estate. If you just mindlessly leave in the clauses about maintaining the escalators because you are afraid to delete things you don't understand, you are creating affirmative legal obligations for your client that are literally impossible to fulfill.
You are creating phantom liabilities. A drafter has to interrogate every single word of the precedent and ask, does this specific mechanism serve the unique facts of today's deal?
And when you are digging through those old archived precedents, you are inevitably going to collide with the next major drafting mistake. Legalese.
Ugh, legalese.
Yeah.
We are talking about clinging to archaic, dusty vocabulary, words like aforesaid, thereof, heretofore.
And those bizarre legal doublets and triplets.
Right. Why do contracts always say things like, the agreement is hereby changed, waived, discharged, or terminated, instead of just saying changed?
Why use four redundant words when one clear word achieves the goal?
Exactly. Why do they do that?
It is actually a fascinating historical hangover that has survived for nearly a millennium.
Wait, really? A millennium?
Yes. After the Norman conquest of England in 1066, the legal system became this chaotic linguistic stew of French, Latin, and Old English.
Oh, that makes sense. Different ruling classes, different languages.
Exactly. So to ensure that a contract was understood by everyone, regardless of their linguistic background, lawyers developed the habit of pairing words from different languages together.
They would pair an English word with a French word that meant the exact same thing.
That is the origin of phrases we still use today, like cease and desist, null and void, or free and clear.
That is wild. So it's literally just an 800-year-old translation habit that got frozen in amber.
Exactly. And Stark is adamant about aggressively eliminating these archaic pairings from contemporary drafting.
They add absolutely zero legal weight to a modern contract.
In fact, they create dangerous clutter. If you use four words that mean slightly different things in common parlance, a clever litigator will try to find a nuance between waived and discharged to exploit an ambiguity.
Clarity is paramount, which brings us to the next massive pitfall: ambiguity and bad math.
Yes.
And the source points a very specific finger at a villain we see all the time, the phrase and/or.
And/or is a drafter's absolute nightmare.
It feels like a convenient shortcut when you are typing fast, but it is a breeding ground for litigation.
Let's say a contract dictates the supplier shall deliver grade A apples and/or grade A oranges by Tuesday.
If Tuesday arrives, what satisfies that covenant? Can the supplier deliver only apples? Can they deliver only oranges? Do they have to deliver a 50-50 mix?
More importantly, who holds the discretionary authority to choose, the buyer or the supplier?
The ambiguity leaves the door wide open for a dispute. And when there is an unresolvable dispute over interpretation, a judge has to decide.
Which means your client is spending hundreds of thousands of dollars in court to define a phrase that you could have clarified with 3 extra words.
There's also the profound danger of misplaced modifiers. The text gives the example of a trailing unless clause.
Oh, these are disastrous.
Imagine a massive executive compensation package. The clause reads, the CEO shall receive a $5 million bonus if year-over-year revenue increases, operating costs decrease, and profit margins double, unless the global market crashes.
Does that trailing unless apply to all 3 of those preceding conditions? Or does it only apply to the very last one about the profit margins doubling?
It is completely ambiguous on its face.
A simple comma, or better yet, breaking the conditions out into a bulleted list, what drafters refer to as tabulation, solves the problem instantly.
But if you bury those conditions in a dense, unbroken block of text, you are practically begging for a lawsuit when the market dips.
And we can't ignore the bad math. The text stresses the absolute necessity of testing mathematical formulas with extreme hypotheticals.
Because if you write a formula for calculating a post-closing purchase price adjustment, and you don't lend the extremes, what happens if the formula accidentally results in a negative number?
This is a surprisingly common disaster in complex financial agreements. The lawyers draft a complex EBITDA multiplier based on the client's current rosy financial projections.
But they fail to run the formula using catastrophic hypothetical numbers.
Right. If the target company's revenue falls off a cliff right before closing, the mathematical formula might accidentally dictate that the seller has to pay the buyer millions of dollars at closing instead of the buyer paying the seller.
The math has to be bulletproofed against every conceivable reality. That brings up another ironclad rule Stark emphasizes: the golden rule of drafting.
See the same thing the same way.
This is a critical lesson in structural consistency. If you change your phrasing in a contract, a judge is legally obligated to assume you meant to change your substantive meaning.
For example, if you're drafting a set of representations, and in paragraph 4 you write, "To the knowledge of the seller, the environmental reports are accurate."
Okay, standard phrasing.
But then, 3 pages later in paragraph 12, you're trying not to sound repetitive, so you mix up your vocabulary and write, "To the best of the seller's knowledge, the tax filings are accurate."
Let me guess. The judge looks at that and decides those are two entirely different legal standards of review.
Exactly. The judge will analyze the text and assume that by adding the word best in paragraph 12, the drafter intentionally created a higher, more rigorous duty to investigate the facts than the standard established in paragraph 4.
Even if you were just trying to be stylistically creative, you accidentally created two distinct legal thresholds.
You must lock in a defined term and use it mercilessly.
It goes right back to the computer code analogy.
Right.
You cannot use creative synonyms when writing C++ tame. The machine needs the exact same command every single time to execute the function.
Precisely. Now, we have to address one of the most psychologically interesting failures in the drafting process. It's what Stark calls the endgame mistake.
Right. The lawyers and the clients have been negotiating for months. They're exhausted, but they finally agree on the core terms,
They are metaphorically high-fiving in the conference room.
focusing entirely on a successful closing day. And because they are so focused on success, they fail to adequately draft the endgame. What actually happens when the deal falls apart before the finish line?
Human nature makes us want to focus on the positive outcome, but the drafter's job is to ruthlessly focus on the failure state. The source text warns drafters to always follow the cash.
If a massive commercial real estate transaction collapses 3 days before closing, what happens to the $10 million down payment currently sitting in an escrow account?
Does the buyer automatically get it refunded? Does the seller get to keep it as a punitive fee?
Does the allocation of that cash depend entirely on why the deal fell apart? Was it a failed condition or was it a malicious breach?
The drafter must map out the exact flow of funds for every single failure scenario. If you don't draft the endgame, the cash gets frozen in escrow and the litigators take over.
Okay, as we are navigating all these rules about drafting, I want to bring up something that feels like a glaring contradiction in the source text. I need you to reconcile this for me.
Okay, let's hear it.
So, Stark spends chapters warning us not to blindly copy old firm precedents because it leads to mindless markups and phantom liabilities, right?
Yes.
She demands that we think critically and draft specifically for the deal at hand. But Galati, later in the text, she explicitly states that when a drafter is dealing with statutory provisions like a specific law or regulation passed by the government, we must parrot the exact words of the statute.
We literally just copy and paste the law directly into our contract.
The text even humorously refers to this as sanctioned plagiarism. Isn't that a massive philosophical contradiction? We are supposed to be hypercritical architects, except when we should just blindly copy and paste.
It looks like a contradiction on the surface, but it is actually a brilliant strategic distinction based on the source of the language. Think about the origin point of the text you are copying.
Okay.
When you copy a colleague's old, archived precedent, you are inheriting a flawed human being's sloppy thinking. You are importing the rushed mistakes, the late-night typos, and the compromise negotiations from a deal that happened 5 years ago. You have no idea why they chose those specific words.
You're just blindly copying another student's homework, mistakes and all.
Right. But when you copy a statute word for word, you are copying the actual objective law of the land. It is a strategic shield.
Give me an example of how that works as a shield.
Imagine a state law mandates a corporation must provide 30 days written notice prior to termination.
Okay.
If you try to be a creative drafter and you write in your contract, the company will provide a month's notice before terminating. You have just introduced massive ambiguity.
Is a month 28 days, 30 days, 31 days? Does the notice have to be in writing or can it be an email?
But if you copy and paste the statute exactly, you guarantee absolute compliance with the law.
That makes sense.
Furthermore, law firms are often required to issue formal legal opinions stating that a contract is valid and enforceable. If you paraphrase the statute, the senior partners at the firm won't sign off on the opinion because your creative phrasing introduced unnecessary risk.
By plagiarizing the statute, you provide the firm with absolute cover. Wow. So copying a colleague is absorbing their risk, but copying a statute is putting on armor. That makes perfect structural sense.
It's all about mitigating risk.
Okay, we've covered an immense amount of ground today. Let's pull back and summarize what we've unpacked regarding the hidden matrix of deal lawyering. Contracts aren't just tedious legal red tape.
They aren't just annoying PDFs that you blindly scroll through to click the I agree button at the bottom.
They are highly structured, meticulously engineered maps of risk, control, and future intent.
And every single one of those complex maps is built entirely out of those 7 foundational building blocks.
Representations to establish the facts.
Warranties to guarantee a remedy if the facts are false.
Covenants to mandate future action.
Rights to receive that action.
Conditions to trigger the obligations.
Discretionary authority to grant choices.
And declarations to define the rules of the game. I want to address you, the listener, directly as we close this out. Even if you never step foot inside a law school, and even if you never sit across the table in a corporate merger, you interact with these private laws constantly.
You sign commercial leases, you negotiate employment agreements, you agree to complex terms of service.
Next time you are handed one of those documents, I challenge you to look past the dense formatting. Look past the intimidating legalese and the archaic doublets. Try to spot the building blocks.
Start asking the structural questions. Who truly holds the discretionary authority in this agreement? Who has the unilateral choice to terminate the relationship?
What are the specific conditions that must be satisfied before your covenant to receive a bonus is activated? And are those conditions within your control, or are they entirely reliant on a third party?
You now possess the analytical X-ray vision to see the deal for what it truly is.
You aren't just looking at the public speed limit sign, hoping for the best. You can actually lift the hood and see the mechanical engine of the transaction.
It fundamentally changes how you assess risk and navigate the business world.
It absolutely does. But before we wrap up this masterclass, I want to leave you with a provocative final thought to mull over. We have spent this entire time dissecting how these contracts act like brilliant, rigid architecture. They flawlessly allocate known risks.
The drafters anticipate the earthquake, the failed server, the delayed payment, the collapsed real estate deal, and they build a structure to withstand those foreseeable events.
They engineer a safe path through the predictable future.
Right.
But consider this. What happens when a rigidly drafted contract built perfectly out of those 7 inflexible blocks meets a truly unprecedented, unimaginable global event?
A true black swan event.
What happens to the strict obligations of a covenant when a once-in-a-century pandemic shuts down the globe? What happens to the representations and warranties when a sudden, unpredictable leap in artificial intelligence completely breaks the global supply chain overnight?
It's a terrifying question for a drafter.
Does the strict, unyielding architecture of those 7 building blocks snap under the immense pressure of the truly unknown? Or is a masterfully drafted agreement actually elastic enough to govern even the unimaginable? Think about that invisible X-ray structure we started with.
What happens when the bones themselves are forced to bend?
Something to think about.
Something for you to ponder until next time.